Sí, te escucho, Mau, no estás seguro.
Gracias, David. Gracias a todos. Voy a nada más a decir en un minuto algo en español para empezar puntualmente con Maxi Scherer, que está ya en la línea, y en beneficio de la puntualidad que podamos empezar. Entonces, gracias a todos por estar el día de hoy en esta sesión. Vamos a grabar la sesión para efectos de las personas que no pudieron tener acceso a ella con la autorización de Maxi. Buenas tardes y espero que todos estén bien. I'm going to switch into English right now. We have the pleasure today of having Professor Maxi Scherer. Maxi is a special counsel at WilmerHale, where she has a very important position there in the arbitration and controversy or dispute resolution section of the firm based in London. Also, she is a person who enjoys very much the academia. She has written several books. Actually, I was telling her that I'm going to buy several of her books. For instance, the international arbitration in the energy sector, or the comments on the New York Convention, I think is a must read for those who like the practice of arbitration. She also is a frequent speaker in international conferences dealing with arbitration. But the reason we were able to have the pleasure of listening to Maxi is because of Carlos Alvarado, my colleague at the firm, where he had also the pleasure of being his student at Queen Mary in Westfield College. Maxi Scherer has a PhD, and she is a full-time professor at Queen Mary University of London in London. Today she's going to be basically speaking from Paris because she was basically stopped there in her way to London. But it's a pleasure indeed and to have Maxi today and be able to listen to her presentation regarding virtual hearings that have become a very important topic in arbitration, and of course artificial intelligence and international arbitration as a topic. Maxi, the floor is now with you. Thank you very much indeed for presenting at the Mexican Bar Association seminar on technology and the law.
Thank you very much, Omar, for the kind words of introduction. It is a great pleasure for me to speak at this event organized by the Mexican Bar Association. I only wish I could be there in person. I'm a big fan of your country and Mexico City in particular, so I'm sad not to be with you in person, but I'm grateful, much grateful, to be able to speak to you remotely. If there is any problem with sound or video, please do let me know. But if I don't hear from you otherwise, you can use the chat function as well. I'll assume that you'll hear me well.
Thank you, Maxi. Just a quick word here that I missed. One, the first part of the presentation will be in virtual hearings. We encourage the participants to write their questions in the chat. After that first portion of the presentation, Carlos Alvarado or myself will basically try to raise questions for Maxi. And after that specific portion, we're going to enter into the artificial intelligence in international arbitration. And the same dynamics are going to apply. Afterwards, there will be questions raised in the chat. And finally, we will close hopefully at 1:30 as scheduled. Thank you very much. I'm sorry the intermission.
Not at all. I actually only meant before I start to thank Omar Guerrero and Carlos Alvarado Moreno, who was, as Omar said, my student some time ago at Queen Mary in London, for inviting me. It's really a great pleasure to. Thanks personally to both of you. The topic of the presentation today is the future of international arbitration, virtual hearings, and artificial intelligence arbitrators. These two topics are somewhat related in the sense that we are going to discuss how arbitration is potentially going to evolve in the days, weeks, months, but also years to come, with the possibility of virtual hearings, just as we now have a virtual conference, but also thinking further whether potentially at some point in the future artificial intelligence is going to replace or maybe assist human arbitrators in their decision making. So I'm going to, as Omar said, I'm going to start with the first topic, virtual hearings. Then I'm very happy to take some of your questions, and then I'll proceed with the other topic, the AI arbitrator topic. So if we go to the next slide on virtual hearings, this is one of my favorite quotes ever. Tech-savvy arbitrators are as rare as vegan butchers. Of course, this is a provocative quote, but the idea behind that is that a lot of arbitrator colleagues struggle with modern technologies. Not so long ago, I sat with a colleague of a certain age, that must be said, who was unable to read his emails. So we needed to alert him by telephone every time something was sent by email. Not everyone, of course, is that bad, but the current crisis certainly forces all of us to engage with modern technology on a daily basis. And of course, the crisis is a terrible thing, but maybe the positive out of this is that we are coming to go out of this crisis more tech-savvy. And this is the purpose of the second quote that is here on the slide. Necessity is the mother of invention. In the current crisis, with the necessity of restrictive travels, of restrictive possibilities to get together, we need to be inventive. And one of the possible inventions is to do virtual hearings instead of in-person hearings. So let me start by defining precisely what I mean by a virtual hearing. So on the next slide is a definition of a virtual hearing. So it's a hearing where two or more locations interact simultaneously by two-way audio-video transmission. That is a quite simple definition that encompasses actually two possible situations. One that I would call a semi-remote hearing, and another one that I will call a fully remote hearing. So a semi-remote hearing, the first option would be where there is one main hearing location with, let's say, the arbitral tribunal and the parties gathering together, and then there is one remote location, for instance, where a witness or an expert is located and the evidence that he or she gives is done remotely. Honestly, this is something that we have done in the past years on a quite regular basis. This is nothing new. I have personally sat in various tribunals where we examined witnesses, we examined experts remotely. I've also been in two situations that were a bit more remotely, in the sense that in one case, one of the arbitrators actually had to participate remotely. He became ill shortly before the hearing was about to start. He could participate, but he was not allowed to travel. And the parties did agree to proceed with the hearing with the one arbitrator participating remotely. And another situation where the tribunal was in London, and that was all three of us.
I'm sorry, Maxi. I'm just going to ask all the public, por favor, si pueden poner sus micrófonos en mute, se los agradecemos mucho. I'm sorry, Maxi.
No worries. I didn't take this as a question, but if there are questions, you can type them in the chat and have an opportunity to ask them at the end. So I was just saying that there was one situation where the remote hearing I was experiencing was actually quite remote, in the sense that the tribunal was based in London, but one of the parties, their legal representatives, witnesses, experts, were all in Australia. And the reason that happened is because it was clear that the respondent wasn't going to participate in the hearing at all. It was a fairly short hearing, and it was determined that the costs and the effort for everyone to come from Australia to London was not worth the while, so we did it remotely. And I have to say, in all of these cases, it worked really well. But that is different from the current situation in which we are in, where we cannot do these semi-remote hearings. What we are actually facing at the moment is what I call fully remote hearings, where every single participant, every member of the tribunal, every party representative, witness, expert is actually sitting in different locations and participating from different locations due to the current COVID-19 crisis. So the question is, how does this work? Is this possible? And how, in practice, can this be done? And these are the questions I want to discuss with you this morning in the next couple of minutes. Now, let's start by looking at the regulatory framework. And on the next slide, you will see a couple of sort of as a starting point. I think the rule is that typically we do have an oral hearing, and particularly if one party asks for an oral hearing, then often the tribunal cannot proceed on a documents-only basis. This is a typical rule that can be found in many national laws or arbitration rules. I have looked at the Mexican Center for Arbitration Rules, the CAM rules, and Article 26.2 actually does say that. The English version says, you will obviously be more familiar with the Spanish version, and the English version says the arbitrator may decide the case solely based on documents presented by the parties unless one of the parties requests a hearing. A similar rule is found in the ICC rules, and this is the one that's here quoted on the slide, Article 25, paragraph 2. The reason I have quoted this in full on the slide is that the wording is somewhat tricky. In that it does say that the arbitral tribunal shall hear the parties together in person if any of them so requests. And this particular wording of saying together in person has triggered the question and has led some to say a virtual hearing is not possible. You have to hear the parties at least partially in person. That's what it says. That is, however, in my view and in the view of many, not the correct reading of Article 25 of the ICC rules. And indeed, if you look at other linguistic versions, if you look, for instance, at the Spanish version, or if you look at the French version of the rules, of the ICC rules, you do not have these particular words of in person. Rather, what it says in a contradictory fashion. My French is better than my Spanish, so I'll say it in French, de façon contradictoire. So what that means that there has to be a live exchange of arguments between the parties. But that, of course, can be done virtually as well as in person. And just to sort of get rid of any possible misunderstandings and hesitations, the ICC has just a couple of days ago issued a note, which is here on the slide as well, the ICC guidance note on COVID-19, in which it does the ICC clarifies that virtual hearings are possible under the ICC rules. But what happens with the other rules? So on the next slide are a couple other possible scenarios. As far as I am aware, there aren't any national rules or arbitration rules from institutions that expressly either impose or prohibit the use of virtual hearings. Rather, what some of them do is that they provide for the possibility, and some of that do that expressly, but these are permissive terms in the sense that it allows the tribunal that it may use virtual hearing. That is very clear under the LCIA rules, which are here on the slide, Article 19.2. So the arbitral tribunal has the fullest possible authority to establish the conduct of the hearing, and that includes that it may decide on the form, and that it may decide that the hearing takes place by video, by telephone, in person, or a combination of those three. So very clearly allowing the possibility of a virtual hearing. There are some other arbitral rules that equally go in that direction. Article 13.1 of the HKIC, the Hong Kong International Arbitration Center's rule, encourage the tribunal to consider the effective use of technology to avoid unnecessary delay or expense. And Article 28.4 of the UNCITRAL rules specifically says that witnesses and experts may be examined through means of telecommunications and do not have to be physically present at the hearing. But frankly, these particular provisions are exceptions, and most of the rules I'm familiar with and national laws that I'm familiar with actually do not specifically address the issue of virtual hearings. So the question is, what happens then if you don't have a specific rule, if there is silence about this? And on the next slide, I have put together what, in my experience, are the most common hypotheses and scenarios that I currently witness in the arbitrations that I'm involved in. The first scenario is that both parties actually wish to hold a virtual hearing and the tribunal is reluctant. The second is that the tribunal is agreeable to a virtual hearing, but the parties are reluctant. And then the third is that one party, typically the claimant, wishes an in-person hearing, typically the respondent, wishes an in-person hearing, whereas the other side, typically the claimant, wishes to proceed with a virtual hearing. Now, what happens in these three types of cases? Well, the first scenario is actually quite awkward, and I tempted to say, if you are in that situation, you have the wrong tribunal. But I have to say, I'm currently sitting in a case where the presiding arbitrator is reluctant to organize a virtual hearing, even though both parties have expressed actually interest in exploring the idea. I think that is quite problematic in the sense that many laws and arbitration rules have the principle that if the parties agree on procedural issue, the tribunal has a duty to abide by the parties' agreement. Article 19.1 of the UNCITRAL model law is here cited on my slide, but I was told by one of my Mexican colleagues that a similar provision is in the Mexican Code of Commerce, which is Article 1435. Please correct me if I'm wrong on this. But the principle is that as long as the parties agree, the tribunal really should follow up on this. But of course, if the presiding arbitrator is not willing or says cannot organize the hearing, then this is problematic. The second situation, which is the converse situation, where the tribunal is actually happy to go and do a virtual hearing, but the parties both are reluctant, I think, again, is pretty clear. If there is a party agreement to insist on an in-person hearing, the tribunal has to abide to that agreement between the parties. So the most difficult situation, of course, is the third one, where there is a disagreement between the parties, one wanting to proceed with a virtual hearing and the other one wanting to insist and requests an in-person hearing. In my view, there is no doubt that arbitral tribunals under most national laws and most arbitral institutions have the broad power to determine what is appropriate under these circumstances, how to proceed the procedure. This is again I think, pretty clear from Article 19.2 of the UNCITRAL model law or Article 1435 of the Mexican Code of Commerce. But the question is, in determining whether it may go forward with a virtual hearing, the tribunal also has to balance out a number of other considerations and take into account a number of other factors. And these are the ones that I've tried to list, at least some of them, on the next slide. So if there is an opposition from one party to a virtual hearing, the tribunal basically has to balance out two conflicting factors or principles. The one is that the arbitral tribunal has a duty to conduct the arbitration as expeditiously and efficiently as possible. This is set forth in many arbitration laws and institutional rules, and again here I quote the Mexican Center rule, which clearly says that. And it is certainly an important aspect that if we, specifically in the current situation, do not allow a virtual hearing to happen, we might go for a quite long delay. And actually, we don't know how long that delay might be. We don't know how long this current situation will last. And even if, say, in the fall we are able to gather together again and have hearings, I already experience now that there will going to be a bottleneck because everyone will want to schedule their hearings in the fall. I've already, in my cases, 4 back-to-back hearings in September and October, so it's going to be really hard to squeeze in more hearings, and other arbitrators are in similar situations. So if the postponing and the long postponing of the hearing has the potential of providing harm to one party, this certainly sort of leans the balance towards going for a virtual hearing. However, and this is the other principle that the tribunal needs to take into account, which is also on the second bullet point here, it is the party's right for equal treatment and right to be heard, which again is really the cornerstone in many national laws, as well as the New York Convention. And basically, if there is a breach of the right to be heard or equal principle, then the award is under the risk of being challenged or set aside. And of course, the arbitral tribunal has an obligation to render an enforceable award. But the question is, does a virtual hearing in and of itself breach either the party's equal right to treatment, the right to equal treatment, or does it breach the party's right to be heard? Now, on the question of equal treatment, in the current situation where everyone is going to be in different places, where we have what I called before a fully virtual hearing, everyone is going to be in the same situation, in that every single witness, every single party is going to be heard remotely. So I don't foresee here so much issue with the principle of equal treatment. It is different, though, in the cases where one party's witnesses or experts are heard in person and the other party's witness or expert are heard remotely via a video link. And here the question arises, is that difference in treatment a problem under the standard of the New York Convention or the model law, etc. It depends, I would argue, quite a bit on the circumstances, whether, for instance, the witness is a significant one, but we can take comfort from some case law around the world that has looked at this and said that the difference between remote hearing and hearing in person is not such in and of itself that the award could be set aside or challenged or refused enforcement. Regarding the other side of the cone, the party's right to be heard, again, the question is whether in and of itself hearing the witnesses remotely would be a breach of the right to be heard. And here I have added 3 court decisions on the slide, 2 from the UK. The first one is a House of Lords decision, and 1 from Singapore, from the International Commercial Court in Singapore. And in all of those, the courts have actually said that the mere fact that there is a virtual hearing is not a breach of the party's right to be heard. Parties can be heard effectively through virtual means, but there can be circumstances where there is a breach of the right to be heard. And that's where, unfortunately, it is a case-by-case analysis. So, for instance, if one of the parties does not have access to the relevant technology, one might wonder whether that might be a breach of the right to be heard. Or if there are deficiencies in the evidence taking because the technology failed, then there might also be a breach of the right to be heard. Talking about technology failures, I don't see the slides anymore. I'm not sure that is the same for everyone. I'm happy to proceed.
Sorry, Maxi, I'm going to hear it again. Just a couple of seconds, please.
Sure. And thanks, Carlos, for switching them so kindly.
It's ready now. My apologies.
No worries. So these are quite recent decisions, as you can see, 2005, 2018, 2019. But my guess is it's going to be really interesting to see what's going to happen in the coming month as well, because a lot of national courts, and I'm not talking about arbitration here, national courts around the world currently actually practice to have hearings be held remotely because of the crisis. And on the next slide are a couple of examples. I have found examples from the Supreme Court in Brazil and the courts in Colombia that have made the announcement that they will proceed with virtual hearings. There is, by the way, this website, Remote Courts, that lists different countries and what's happening there, and there are a lot of different countries around the world at the moment who are forced to and do experience virtual hearings in their local courts. Now, the fact that that happens in local courts is in and of itself not directly relevant to arbitration. But if you think about it, if it is possible in national local courts to have a hearing remotely, it will be difficult for the same courts in that jurisdiction to say, if that happens in international arbitration, that is a breach of the right to be heard. So this has the potential, the crisis here has the potential to be a real paradigm shift, in the sense that because it's also done in national courts, the potential reluctancy of national courts will fade away. And the other element that's here on the slide is a survey that was done in the US with judges that who use video recording on a regular basis. And they were asked in a survey what they thought about this. And some of those findings I thought were really interesting. Overall, these federal judges said that the advantages of virtual hearings, obviously the time saving, cost saving, the flexibility, outweighed the potential downside. So overall, they all agreed it was beneficial. And what is also interesting is that those judges who were more experienced with virtual hearings did say that they saw no difference at all, and that the fact there was no in-person interaction did not change at all how they felt. They said, I have the same understanding of the case, I ask just as many questions, I interrupt just as often when people speak, and they overall said that it didn't, if the technology worked, didn't actually change much. the less experienced judges sometimes seem to suggest that there was a lack of personal interaction, and therefore they didn't get the same feel, and with their, not co-arbitrators, but co-judges, and with the parties before them. But what I think is really interesting here is that one reading of this survey is that the more you are used to virtual hearings, the more you find it normal, the more you will actually accept that you don't need an interpersonal reaction. So on that basis, as I said, I think the current situation has the potential of a real paradigm shift, and that virtual hearings become the new normal, as we say at this stage. Now, on the next slide, I just wanted to go on and think together with you what are the actual practicalities to organize such a virtual hearing. And I wanted to share with you here some of my personal experiences and thoughts. And it is certainly true that virtual hearings are more complicated and need very careful planning, very careful planning in advance. Here are a couple of points, certainly not exhaustive, but a couple of points to keep in mind. To apologize. The first, of course, is the choice of the technology. What type of platform or provider you will want to use for the virtual hearing. And here I want to plead towards parties and arbitral tribunals to keep in mind very important considerations of data security and confidentiality. We are lucky these days that there are a lot of different commercial providers for video conferencing services, etc. But some of them, if you read carefully the general terms and conditions, actually take ownership of the entire data that is used during the video conference. And that, of course, is problematic for an arbitration that is supposed to be confidential. And in addition to that, you might have seen that there were also quite a few recent reports on some commercial providers, and Zoom in particular, which we're using at the moment, that there were problems with the encryption, end-to-end encryption of the data that is used in the video conference. And that means that third parties, unauthorized third parties, might have access to the data during the video conference. And again, that is, of course, a serious issue. All of these can be fixed, but one needs to be very mindful when choosing the right platform, when choosing the setting that one uses for the platform, not to have problems later on with confidentiality or data security. The other very practical tip I would say is to use multiple testings, not only one, but actually several. My experience has been useful to have one testing that is done actually as early as possible when you determine to have a virtual hearing, months before potentially the hearing will take place, so that you can see whether there are any issues of compatibility with the different systems used. And then at a minimum, another test just before the hearing starts to make sure that everyone is on track. We had one yesterday for the seminar, and as I found out, there was actually a problem with my computer, which I was able to fix and be able to talk to you today. When you have a virtual hearing, you also need to have a very detailed procedural order dealing with this, and it is helpful if that procedural order contains a number of provisions. Again, I have some examples here on the slide. One is I'm sorry, this is still going back to the old one. Yes, one is you certainly want to provide for shorter hearing days than the usual in-person hearings, and that is that you need to account for technical failures. There will be at some point during a couple-day hearing, there will be technical failures if you do it by video. So you need to make sure that you have the leeway and you have to have shorter hearing days. I would definitely recommend that. Because of that, I think it's also very helpful to have a backup plan. Have a plan. What happens if the technology fails? If all of a sudden the connection stops? How will the parties communicate with the tribunal? Who contacts whom in which channel? And it is helpful in my experience to actually put that down in the pre-hearing order before things start. If during the virtual hearing witnesses are going to be addressed remotely, you want to make sure that no one is in the room so that you can't potentially coach the witness, suggest answers to the witness. That again can be done quite easily by looking around the room and not using any virtual backgrounds as I do here, which are obviously can be suggest that there is no one in the room. Electronic hearing bundles, I would say, are a must, so that rather than having hard copies, you actually all share the same file that is held electronically, and there are very good commercial providers that can put the documents on the screen. If you just give the reference, someone sitting remotely will be able to put it up on the screen, just as Carlos now very kindly is controlling the presentation. Two more points. The breakout rooms, as we usually have them in hearings, can also be organized in a virtual hearing. Many platforms actually allow for virtual breakout rooms. Zoom certainly does, so that you can split up, say, the claimants have their own virtual hearing room, the respondents have their own virtual hearing room, and the tribunal has its own breakout room, so that you can have discussions privately, deliberations, briefings on how things have gone during the morning session or whatever. And last point, it is important to discuss upfront if this is going to be recorded, who is going to record it, and that the recording is going to be shared. Now, there are many other aspects that I'm not able, for matters of time, to go through here. For instance, if you have interpretation, translation, court reporting, these are all additional complication factors in a virtual hearing that need to be dealt with. Now, the good news is, and this is the next and last slide for this particular topic, is that you don't have to reinvent the wheel each time. There are now very good guidelines out there, and I have put a couple here on the slides. I'm not going to go through them in detail. Some are more specific to arbitration. The last one, for instance, is on an evidence-taking convention between the Hague Convention, but it has very good tips on how video link evidence-taking can be done. Some of them are specific to this crisis, such as the ICC or the Delos checklist. Others are more specific, more general about remote hearings and not only for dealing with the current crisis. And you can also find some template procedural orders that include some of the points that I've just outlined for your case if you are going to proceed with a virtual hearing. So let me conclude on this first part of the topic, and I'm very interested to hear your thoughts and questions. Of course, it seems to me that virtual hearings, to a certain extent, can be the last piece of the puzzle. If you think about it, international arbitrations are already done remotely almost exclusively. Requests are filed remotely. The exchange of submissions are now done exclusively mostly on an electronic basis. We don't need hard copies anymore. Case management conferences, very often in my experience, are done by phone or video conference as opposed to in person. Arbitral tribunal deliberations are at least partially done remotely by phone or video conference. And so really the only thing that is still very much at the heart and...
Perdón, Maxi. I'm sorry, Maxi. ¿Pueden poner en silenciador su micrófono, por favor? Que se está oyendo ruido adicional. Mil gracias a todos. I'm sorry, Maxi. Thank you.
Not at all. I'm going to shut up just in a second. All I was going to say is that really the last piece that is missing, where we do meet in general in person, is the hearing. So if we have a virtual hearing, then we are going to have an entirely remote arbitration with no personal interaction whatsoever. Now, whether that's a good thing or a bad thing, I leave it up to you to conclude. And as I said, I'd be very interested to hear your thoughts and, if I may, answer any questions that you'll have before we proceed to the other topic.
First of all, thank you. Thank you very much, Maxi, for this very important and timely portion of the presentation. There are indeed, I think, important challenges nowadays regarding how to conduct and perform a virtual hearing, especially because sometimes my perception is that this kind of electronic tools were more used as an exceptional basis, because one of the main features of and benefits of arbitration was to have the immediate contact, and I will say even the transpiration with the arbitrators and of course with opposite counsel. Now it has provided a huge challenge, and I think one of the questions that have come from the attendees is precisely, and it says verbatim, talking about the hearing and the equal treatment and right to be heard. What if one of the parties has technological difficulties and the other does not? So one party is not able to get its message or evidence correctly heard. And probably complement that, is that a ground, in your view, in your experience, for setting aside or annul an arbitration award, or in case to refuse recognition and enforcement?
It's an excellent question, and it is, to a certain extent, the $1 billion question. Maybe there is a distinction to be made whether one party says upfront, I'm not going to be able to do this virtual hearing because I cannot have the technical standard that is required. And I think here one needs to be mindful of the fact that we all do not live necessarily in the same sort of, comfort zone. I am certainly at the moment part of a tribunal where one of the parties is based in a region where that argument is credible. And because we cannot move in the current COVID-19 situation, it might be a real credible argument that that party cannot organize the virtual hearing because the technological standards aren't there. The other part of the answer I would like to give is, and maybe this is what your question related to more specifically, is what if it happens during the hearing? So what if, we are actually deciding to go for virtual hearing, and then during the hearing there are technical difficulties. And I think here it very much is the responsibility of the presiding arbitrator to deal with this situation. Very often, in my experience, these can be fixed. I've had no virtual hearing or semi-virtual hearing where there were no technical issues, but very often these technical issues can be fixed. So I think it is important that the presiding arbitrator, rather than letting it go and proceeding with the hearing with those difficulties, actually stops the hearing and says what can be done to fix it. And that's also why I said earlier we need to have shorter hearing days because you need to account for these situations. A couple of very practical things is to turn off every single phone, iPad, or whatever you have around your computer that is using the video conference. It is still interfering. Unfortunately, I've had practical examples where just by saying, "Can you turn off your phone?" or just put your phone a little bit further away, everything was fine. So very often, I think these problems can be dealt with. If they persist, I think it would be problematic to proceed with the hearing because, if you can't hear the witness, that is equivalent to a witness not showing up or a witness not being able to speak, or you cannot have then a proper right to be heard if a witness is not properly examined, or you cannot make your oral argument. But luckily, in my experience, these technical problems typically can be solved.
Right.
Sorry, go ahead.
No, please go ahead, Carlos.
There is another question from the audience, Maxi. They are asking, which video conference software do you recommend to hold secure and confidential hearings?
Yes, that's a really hard one. I typically don't recommend anything because they all have flaws, and I don't want to be responsible if something goes wrong. And I don't, I'm not selling them. I don't get any shares if I say that, Zoom is great, which I actually don't think is great for hearings, to be honest. In my sort of the thumb rule, the cheaper it is, the more technical problems you have, security problems you have. So there are quite expensive, customized systems for arbitration that are actually pretty good. And I think the sort of top level, in my view, is what institutions offer. I mean, some of the institutions, the SEC, in my experience, SIAC, Hong Kong, they all offer actually virtual arbitrations software and providers, and I would hope that they have thought about this quite carefully. So if you want to go for the gold standard, I think that is probably the right solution.
Thank you. There is also another question. It's in the chat. What kind of safety measures can be taken in order to avoid that third party may be providing assessment when a virtual hearing is taking place?
Providing assessment in the sense of coaching witnesses? Is that how you would understand the question?
I understand in that way, yes.
Okay. Well, first of all, I remember this is like 10 years ago. We did examine a witness in Africa who was unable to join the hearing because of visa issues. And we, first of all, asked the witness to sort of stand up so we could see whether he had anything sort of, on his body. We did ask him to turn around the laptop so that we had a full view of the room. These were very, very bare settings. This was last minute, and really it wasn't the best. But still, with even these simple measures, we were able to at least see that no one was in the room, etc. If you go for the sort of upscale video conferencing facilities at institutions, which in the current crisis are not available because you actually have to physically go to the institution's video conferencing center, they typically have cameras all around the room so that if you want to, you can check whether there is someone else in the room. Now, we discussed this actually last week in another setting. You could, of course, imagine that while there, you have a laptop in front of you, like we all do now, that there is, a window opening where someone remotely chats with the witness and gives the witness any sort of hinted answers. I think that becomes quite complicated, and I would guess you find that out. If the witness is, not answering questions but actually staring at the screen trying to read something, you do know that something fishy is going on. So we sometimes sort of try to think about worst case scenarios in a virtual hearing, and we forget that in-person hearings can have flaws too. I've seen arbitrators fall asleep. I've seen arbitrators having problems hearing because they, have a problem. And you kind of think, well, clearly that person didn't get the evidence. We might have other issues. So I think it's not a black or white. One is excellent, the other one is bad. I think they're different, and I think we need to adapt to different environments, and we need to be mindful that they both have flaws in different ways. I hope that answers the question.
I don't know if there is someone that would like to make a direct question to Maxi regarding this first topic.
Carlos, creo que hay 2 o 3 preguntas adicionales en el chat, por si.
Okay, so we will continue with the questions in the chat. Have you had experience that an arbitration award has been set aside due to problems occurred in a virtual hearing? For instance, no opportunity to present the party's case, or say same situation for denial of recognition and enforcement of an award.
I'm not aware of any. I've done research. If you find some, do send them to me. I'd be very interested. As far as I know, no. What I have seen is that courts have raised issues, have said one could think of a hearing being or an award being set aside due to a virtual hearing if there are deficiencies during the evidence taking. But as far as I'm aware, no award has been set aside. So I think the bottom line is a virtual hearing in and of itself is not a problem. It's only if there are additional issues, additional problems that come along in a specific case that then you might risk a set aside. And it depends, of course, where. I mean, some jurisdictions are so arbitration friendly they would probably not, and others might be more difficult. But if you find an award where it has been set aside, please do send it to me.
Will do. Maxi, do you think we can take a couple of more questions, or do you think we should move with the second part of your presentation and at the end taking more questions?
Look, I'm happy either way. I think if there are questions, I'm happy to answer them. I can, deal with the artificial intelligence arbitrator very briefly. Maybe this is more of a sort of futuristic idea, and right now the acute question really is about virtual hearings, so I'm happy to take more questions.
Omar,
I'm in your hands.
Basically, there are a couple of more questions here, Maxi. One of them refers to translation and how to deal properly with those issues, especially in Mexico, where sometimes the translators are not adequate prepared, or their skills are not as good as you would like to. How do you handle those problems? And the second one is basically, how do you make, as an arbitrator, the task to identify properly a witness if you have never seen that specific person? I know that in other jurisdictions it's a bona fide, good faith kind of situation, but in Mexico sometimes we're obsessed with those formalistic issues to have an ID and to present itself, and etc.
So, excellent questions. The first one with the translators and interpreters, I have to say this is the one that really gives me a headache. I have never experienced myself an arbitration where there was interpretation and a virtual side of the hearing. So I cannot give you my experience with it, but I've had colleagues and I've heard from other people. What they usually do say is it has to be a sequential interpretation, so that you have one question, you translate it, and then you have the answer, rather than simultaneous interpretation that with virtual hearing becomes really almost impossible to organize. The other thing that I've heard works well sometimes is if the question can be maybe asked in one language, and very often sometimes the witness actually understands, say, the proceeding is in English and the witness speaks Spanish and there is an interpretation in Spanish. Very often, or sometimes, the witness speaks English well enough to at least be able to understand the question, so that you would actually hear the question in English, but then answer in Spanish because that's your mother tongue and you're more comfortable in replying in that question. And then you would have a translation of that answer for the record. The other question really is, where is the interpreter supposed to sit? Is it supposed to sit, he or she, with the witness or with the arbitral tribunal? And again, I don't have experience with either situation, but I've heard that it works better if the interpreter actually sits with the tribunal as opposed with the witness, so that there can be some interaction, COVID-19 permitting, between the arbitral tribunal and the interpreter if necessary. But these are really important questions that add to the artificial nature sometimes of the exchange for instance, a cross-examination. And that maybe leads me to the other question, how do you recognize the personality of a witness online? So I think there's sort of two sides of this. The one is the aspect that Omar mentioned, that we need to make sure that the person is really that person, and you might have to request an oath from that person and showing the ID, etc. I think there are ways of doing that online, with facial recognition, etc. That can be done, virtually quite well. What a lot of people, and this is sort of the other side of that question maybe, what other people often say is, if I don't see a witness, if I don't see a person, I will not be able to assess the credibility or the weight of that evidence. And that's also, partly of what has been put to the judges in this survey in the US that I quoted before. And most of the judges actually did say, it felt the same. And I have to say, from the experience I had, I was not cross-examining, I was on the tribunal side, but it almost felt more immediate, because you have this big screen that was not on a computer, it was on a big screen. We had this big screen in front of us with the witness or the expert testifying. You see every single blink that person is doing. You see every single twist of the mouth. And so you can, I think, if it works, if the technology works, you can hear any change of voice. You can see any change of, facial expressions much better than in a hearing room, where very often the expert or a witness sits 5 meters away from you, or however, and you might not see it so well. Or in the case I mentioned earlier, an arbitrator that doesn't hear very well cannot sort of put the volume up. A witness will speak however loud he or she can speak. In a virtual hearing, you can put the volume up as much as you want. So to a certain extent, maybe you can assess the credibility of a witness better. But I am mindful of the fact that this is something that comes up again and again and again. And I think it's more of a psychological question. If you have the impression that someone is very far away because you're just speaking to the computer, you don't take so much the gravitas of the situation in the same manner as if you were sitting together in the same room. And one thing that seems quite stupid, but I think changes significantly is, for instance, if all the arbitrators have a virtual background, and that virtual background has the view of a hearing room, and maybe all three have the same virtual background of a hearing room. And my sense is sometimes that makes that bit of a difference, that people actually do think, oh yes, this is serious. I'm actually, speaking to this tribunal, and it feels as if they were sitting in a room together. So we'll see. I mean, I'm not a psychological professor. I don't know about the psychological effects of this, but my experience certainly is that I had the impression that the evidence of witnesses and experts given we could assess it very well.
Thank you very much, Maxi. Very interesting, this first part of your presentation. There are, I think, one additional question, but if you agree, we can continue with the second part. And luckily, at the end, there will be more time for further questions. So if it's okay for you, I will share the slides.
Sure. I'll be quick. Also because I think the organizers have shared an article that I have written some time ago on artificial intelligence and legal decision making. So if you're interested, you can maybe read that. So I'll try to be really brief now in the next couple of slides to make sure that we can come back to some more of your questions, which I think are really interesting. So artificial intelligence arbitrators, the question here is whether at some point in the future artificial intelligence will be able to replace or assist human decision makers as arbitrators. And when I discuss this with colleagues, the answer I usually get is along the lines that is here on the slide, that legal decision making requires cognitive and emotional capabilities that machines simply do not have. And of course we all agree with that. But as I will show you in the next couple of slides, there are studies that are quite impressive when it comes to what computer programs can do compared to human beings. So what I'm going to suggest, Carlos, that we're going to skip the next two slides, which are basically defining artificial intelligence and how it was developed, and go straight to those studies. And there are what you call studies of predictive analytics. So the idea is how much a computer program, an artificial intelligence algorithm can predict whether or not a legal outcome is correct. And there are a couple of studies. There was an earlier study in the US in 2002 where it was very simple. It was just, the question was just to predict the outcome of the US Supreme Court decisions of the next term. There was a group of human experts, eminent lawyers, well-known, renowned law professors, and they were asked to predict the decisions of the US Supreme Court. And to be honest, the results actually were quite underwhelming because they only got it right in 59.1% of the cases. If you think that if you flip a coin, you already have 50%, that is actually not very good. The computer model was able to predict it in 75% of the cases, so was doing much better than the human decision makers. Now, this was a sort of short and not very well developed analysis, but there are two more studies that are significantly more detailed. One is on the next slide. It's from 2016, and it looked at decisions from the European Court of Human Rights in Strasbourg. They took a data set of about 600 decisions on certain articles on the European Convention on Human Rights, and they trained the computer program on a subset of 10% of those decisions. And what they did is they fed into the system the actual text of the decision, without the actual decision, but just sort of the facts, the procedures, the submissions of the parties. And through machine learning, the algorithm learned to, and then they said, did they win or did they lose? Was there violation or no violation? And so the training was done on this subset. They then applied the algorithm that they had gained with this machine learning exercise to the remainder, the other 90% of the decisions. And the computer program was able to predict almost 80% of the outcome correctly. Now, I think that's a stunning result if you think about it. The next year, 2017, and that's on the next slide, is another study with the US Supreme Court, which I think is actually even more stunning, in that in that particular case, they took decisions from over a century, over 100 years, from the US Supreme Court from 1816 to 2015. These were more than 28,000 decisions and more than 240,000 individual votes of the justices. As you know, in the United States, the justices vote individually. And again, they trained the algorithm on a certain subset. And what they did is for each decision they labeled, they gave the algorithm some information. Who are the parties? What is the circuit from which the decision came up to the Supreme Court? What are the identity of the justices? What are their what law school did they go to? What are their political orientations? What was the procedure before the Supreme Court, etc., etc. And with that training, again, a machine learning training, they put together an algorithm which they applied to the rest of the data set. And here the outcome is a little less in terms of the numbers, only between 72 to 71%, 71.9% of the cases. But think about it, it's even more striking that for decisions that span over a century and that span over every single possible decision that is taken by the US Supreme Court, i.e. everything in the law, the computer program was able to make those predictions in 70% of the cases correctly. So when you think about that, you probably think, it might be possible that at some point we will have artificial intelligence decision makers. There are, however, some inherent limitations, and this is the next and last slide that I have. Inherent limitations for AI models when it comes to legal decision making, in arbitration in particular. The first is you need to have a lot of data. The more data you have, the more accurate your machine learning algorithm will be. Now, the problem in commercial arbitration, at least, is that most of the cases are confidential. So we actually do not have access to the data as one would wish. And even in investment arbitration, where awards are published, the sample size, the size of the data set is probably still too small. But I wouldn't overstate that hurdle because, in my view, it's only temporary. I mean, the institution can potentially, on a confidential basis, put the data sets they have together and have a machine learning algorithm apply to it. So I think there is some leeway here. And I've talked to the International Federation of Commercial Arbitration Institutions some 2 years ago that this might actually be a possibility. Now, the other hurdle is that in all the studies that I've just explained to you, the output, the task that the computer program was supposed to do was binary. It was yes or no. Was there a violation? Yes or no of the European Convention of Human Rights? Would the Supreme Court decide to reverse? Yes or no? And it's always a binary task. Now, that works well for Supreme Courts or for the European Court of Justice, European Court of Human Rights, for Supreme Courts generally. but it does not work so well for, lower court decisions and decisions taken by arbitrators, where you need to establish the fact and you actually need to take a very subtle and varied position on the law and the facts. It's not a binary yes or no answer. The other inherent limitation, just briefly, is that very often these algorithms also have biases that we usually think of human decision makers to have. There are examples from around the world that computer programs become racist or gender biased, and the underlying it's actually not astonishing because the algorithm is only as good as the data that you feed into it. So if the underlying data is infected by certain racial biases or whatever, you will still find that bias in the algorithm. So think about this, for instance, for investment arbitration, where some people say, I'm not saying that they are right, but some people say that arbitrators are inherently in favor of investors. Now, if that were true, and if we were to establish an algorithm, that algorithm would decide more in favor of investors than states. That's just an example how data bias can also be in algorithms. And the last, and in my view, actually the most important hurdle, is the inability to provide reasons, legal reasons, that is. The correct outcome is one thing, but we also need to explain to the parties why they lost in particular. You might not be interested to hear why you win, but you need to know why you lose. And that is difficult with AI because the way AI works, and this is the slide that I skipped, it's basically a probabilistic analysis. It's a calculation of probabilities and statistics. So the answer a computer program would give why you lost would be because there's an 82% chance of you losing. Now, obviously that is not a very satisfactory answer for very many reasons that I can't now go into detail with, but what you will see is that, in my view, there are inherent limitations of AI models, but I also think that AI will shape the future of arbitration, and already does, when it comes to legal research, when it comes to appointment of arbitrators and selection of arbitrators, e-discovery, and probably will also shape the way we make decisions. I don't think they will replace human arbitrators just quite yet, but I think it might very much influence the way we think about legal decisions. You can think, for instance, the party wants to know, going into a settlement discussion, what are my chances of winning or losing? AI model might be able to give you that much more accurately than any human decision maker or lawyer. So I'll stop here. I promised to be short on that one. I hope that was still understandable, even though I rushed through it quite a bit. But as I said, I'd be happy to go and take some further questions.
Thank you very much, Maxi. I don't know if someone from the public would like to make the question directly, or otherwise we can go to the questions made through the chat. Okay, so there are many questions here, Maxi. The first one is, what is your opinion on using artificial intelligence and big data to predict an arbitrator position / ruling on a matter, and select based on that, I assume, and select or recuse him or her for that case based on that prediction?
Yeah, very good question. So I think the idea would be to say you would have something like these algorithms not for cases in general, but for a certain arbitrator. Now, in order to do that, you again would have to have available data. You would have to have access to decisions, quite a few decisions of that arbitrator, in order to actually establish the algorithm that will be able to provide you that answer. Now, I think that is actually quite difficult, because even the most prolific arbitrators have only rendered such a number of awards in his or her lifetime. And add on to that very often these decisions are the result of a 3-member tribunal. And you might not be able to attribute a decision necessarily to this or that co-arbitrator or presiding arbitrator, for that matter. So to have enough data to be able to predict the outcome a certain individual would take on a case, I think is far-fetched. If that were to happen, I think you might be able to recuse someone, but I think we're far from getting to that, if I understood your question correctly.
Great, thank you. Then someone says, artificial intelligence may be good at predicting the outcome of the award, because at the end of the day, it is applying rules for a given case, which could potentially be converted into an algorithm. But the main challenge is for artificial intelligence to truly understand the context of the case, and most particularly the intentionality of the parties. It's more like a comment. What
yes, I think that is. I'm happy to comment on the comments or not, but I think it's a very fair analysis. The question is, what's the outcome that we wish? Do we wish to know why a certain outcome has been reached? At the end of the day, if AI is possible, to get a 90%, 80% correct outcome, do we care how it gets there? Do we care whether it understands the particular context of the case? It doesn't. Of course it doesn't. AI is unable to understand anything. But if through pure mathematics, pure probability analysis, through pure statistics, the outcome is correct, do we care? I'm not saying we shouldn't. I'm just saying that is the question. I actually do think we should care, but I think that's the sort of underlying, really important question.
There is another one here. Besides for artificial intelligence arbitrators, how else can we use artificial intelligence in arbitration?
Yes, plentyfold, and we all do. We all do necessarily without potentially even noticing. Any legal research that we do has some form of artificial intelligence. You put in a couple of keywords and you get the most relevant articles. You could have a voice recognition program where the sort of Siri type or Alexa or whatever they're called, where you could say, Alexa, what's the definition of arbitration agreement under Japanese law? And then Alexa would, look up in the internet and give you the answer. You could also think about e-discovery, and that's already very much in use, where rather than having first-year associates or contract lawyers go through documents and documents to assess whether or not they're relevant, that could be done maybe more accurately by some machines. Selection of arbitrator, potentially. This goes a little bit towards the earlier question that we had. maybe you are going to say, I want someone in this case who is set in X number of arbitrations, is of a certain nationality. You might think of a couple people, but with technology, I'm not sure this is artificial intelligence, but at least technology, you might get to certain names that you can't necessarily immediately think of, and the arbitrator intelligence project that my colleague at Queen Mary, Catherine Roger, is doing certainly goes in that direction, trying to enhance and level the playing field when it comes to access to information on certain arbitrators.
There is another question from the chat. I have heard that big retailers are solving millions of disputes through artificial intelligence dispute resolution systems. What do you think about it?
So I think that is very much already the case. I don't want to give any particular names, but sort of the Amazons and eBays and Airbnbs of this world already have certain dispute resolution mechanisms that have AI factors. Why? Because they have a massive amount of disputes, and that these disputes are quite repetitive. So they can do what I think in arbitration might be difficult to do, because we don't necessarily have repetitive questions. We might have in investment arbitration some repetitive legal questions, but in commercial arbitration, at least, every case is quite different, and from a legal and from a factual perspective. But these repetitive questions will certainly be in the front line when it comes to developing AI. I'm spent in the fall some time in Singapore presenting the paper on AI, and had the chance to talk to the Chief Justice there. This is the President of the Supreme Court. And he shared with me, and this is public knowledge, I'm not preaching any confidentiality here, their plans, and this has now become live, of actually making a AI developed platform for road accidents. So if you have a road accident, you just type in some features of that road accident, and the AI calculates your chance of getting the damages and how much you would get. Now, the reasons that is done is to avoid disputes, so that you can actually, on a level playing field, negotiate with your insurer, and you are able to have an idea, a rough idea at least, what you should be able to get in front of a court. Because insurer, on the other hand, have that information because they have multiple repeat cases. If you're involved in a road accident, most of us never had one, luckily, and if you ever have one, it's only one. So you're not a repeat play of road accidents, hopefully. So in order to level the playing field, AI can sort of provide access of information on both sides. These are all examples where repetitive disputes and repetitive questions will be able to use AI quite effectively. And I could go on and give you examples, but I'll stop here. I hope I made it clear that there are certainly ways that AI can be used here.
Ahorita la computadora no.
Paquito, creo que tienes tu micrófono abierto. Please go ahead, Carlos, with a couple more questions if Maxi is still available.
Sure.
Okay, there is another question here. Do you know of any challenge of an award precisely on the grounds of bias on e-discovery?
No. Bias in the sense of I'm wondering where a bias in an e-discovery could occur. I guess if there is a flaw in the system because of the underlying, I'm not aware of any. Sorry, I'm gonna not start thinking about it. I'm not aware of any.
she's making a precision here. She's referring to bias by the programmers.
Yes. So here's an interesting point. When I first started thinking about AI, that was my main concern. I thought, what happens if the programmers have a certain idea and put it in the algorithm? But the way AI and machine learning AI works is there isn't a programmer programming the algorithm. The algorithm is actually extracted from the data. This is what is quite complicated from a technical point of view to understand. That's maybe sort of the data mining analogy here is quite helpful. You have massive amount of data. You have to go through all of them in order to get a little bit of gold, whatever else you want to be mining. And that little bit of gold is your algorithm. Think about spam emails. Think about, quite easily if you read an email whether it's spam or not. But you would be really hard-pressed to write an algorithm, a series of precise instructions when an email is a spam and when it is not. But if you give a computer program massive amounts of emails that are labeled as spam or as not, the computer program will be able to extract that algorithm, will be able to extract why, in a certain case, there is a likelihood for it to be spam or not. My favorite example is, if you have Viagra in the email, it's probably spam, at least I hope. So that's one example. But what that means is that the algorithm is not necessarily done by the programmer. So any risk of undue influence by the programmer is maybe more limited than we think it would be. I hope that answers the question.
Thank you. Now, Orlando, he makes a comment. He says, under UNCITRAL Model Law, Article 31, the parties may agree that the arbitration award do not state reasons. Thus, artificial intelligence may be useful for small amount disputes.
Yep, absolutely, and maybe not only small but also big amounts. I remember talking to clients, and they say, we don't actually care so much about the reasons. All we want to know is it yes or is it no? And we want to know that fast. We don't want to wait for 5 years for this arbitration to finish. We would rather lose today than win in 10 years. We don't want to have that uncertainty 10 years. I mean, of course, it's better to win in 1 year, but you know what I mean. So even some bigger amounts of disputes, parties might well say, we take the risk. If this program is said to be 80% correct, let's do it. It's a bit of a gamble. We don't have any reasons, so we don't know why, but the parties might agree to that. I would add, the problem is more from a systemic policy point of view. If you don't get reasons, the parties don't know what they did wrong, and so they cannot adapt their behavior for the next time. So they might do the same mistake again. You would also not be able for other tribunals, provided that the award is published, to follow the analysis. They couldn't be able to say, oh yes, I agree with that because I agree with the underlying reasons. No, they would only see the result. So from a sort of more systemic point of view, not having reasons is actually quite problematic. But yeah, it's a very fair point to say that some parties might go for that.
Absolutely. There is a final question, at least from the chat. She says, in one of your papers, you mentioned that artificial intelligence makes conservative decisions. How do you think this affects human rights matters on tribunals? For instance, 200 of years ago, there will not be a recognition of gay or abortion rights.
Yep. Yes. These are the wonderful examples where I think AI gets really to its limits. Specifically, when you think about, for instance, the recognition of gay marriage, we sometimes went from prohibiting gay marriage to prohibiting any restriction of gay marriage. So it went not just a little bit and gradually, it went 360 degrees, opposite direction. And that is something that AI could not have predicted, at least not from the data it was given, i.e. the previous decisions. This is more due to a certain social change in society. But if you think about this in commercial law, these examples are quite rare, where you have a total change of the underlying policies. I cannot come up with any examples, and in my paper the only example I could come up with is the recent Acmea decision in investment arbitration, where I think that has the potential of changing a lot in the investment arena. But in commercial disputes, if you have any examples, please do send them to me. The other thing I would add is I have discussed this with some computer scientists, and some of them actually disagree with that point and say I'm trying to get their point over, that computer programs are not more conservative than humans, because humans also only rely on their past experience. We don't have yet the experience of tomorrow. So humans also only have past experience, and that's the same for computer programs. So computer programs will not be more or less conservative than human decision makers. I'm not sure I agree with that, but I think that's what their argument is.
Great. Now we received a question via email. Sometimes in construction disputes, some generic claims include dozens or hundreds of specific claims with a similar factual background. For instance, claims for underground interferences. Instead of having to review the site conditions associated with each claim, will it make sense to select a sample of those claims and only review, even visit, some of the sites and established criteria will apply to all the claims within this category? Is this something that can be done with simple statistical analysis, or should this be an area for algorithms or any other approach?
I love that idea. I have to say, I never thought about this, but I think it's an excellent idea. I certainly, in some construction disputes, would have loved to be able to say, okay, we're going to decide two sample claims, and then push a button, and then the rest is decided automatically. I think it might be doable. Again, I'm not a computer scientist. I think but it might be a really good idea to sort of try to think how you can model that in an algorithm, so that you decide a couple of sample cases, and then the computer program figures out where other cases are similar and where they're different, and therefore extracts the outcome from that. I think that might be possible from my understanding. Excellent idea. I like that.
Thank you, Maxi. Omar, there are not further questions. I don't know if you have some.
Thank you. First and foremost, thank you very much, Maxi, for your excellent presentation. You were able to summarize very timely and important concepts on both subjects that you basically presented in your lecture today. Yes, I have one very quick question. You mentioned while you were explaining that artificial intelligence as decision maker probably could be helpful in certain low-cost arbitrations and eventually high-cost arbitration where the work could be quite routine or similar, etc., and so on and so forth. When do you think, I know it's a futurist question, when do you think artificial intelligence is going to peak and be able to start making much more complex decision-making process as an arbitrator? And do you believe that that's going to eventually change the way that special institutional arbitration is going to be performed in the future?
I usually try not to make predictions, but you push me, and so I give you what my prediction for what it's worth. I think the way AI is going to change the way we conduct arbitration today is not sort of from the front. I think it's going to come from the back door. What I mean by that is it is going to change the way parties approach settlement discussions. It is going to approach the way third-party funders are going to provide funding to the parties. If they rely on statistical analysis, if they rely on algorithms that predict correctly the outcome, it will affect necessarily the way legal decision making is done. And that in turn, I think will affect arbitrators' behavior, will affect institutionals' behavior. So this is why when I talk about AI, I always sort of try to point out what I think the hurdles are. But at the end of the day, my message is get engaged with the discussion with AI, particularly I say that to my students, to younger generations, because it is going to hit you. It is going to hit you necessarily, and probably rather sooner than later. But I don't think that we are going to have tomorrow sort of machines sitting on the tribunal deciding cases. But maybe this is my own bias because I'm an arbitrator and I don't want to be replaced. We'll see.
No, fair enough. And thank you very much indeed, Maxi, Professor Scherer, for sharing precisely in this occasion your thoughts, your wisdom. I encourage very much the attendees to read your papers that we post in our webpage. And from the distance, we can thank you very much indeed for your generosity in being available to speak with us today. Hopefully it's not going to be the last time, and we will probably abuse of your generosity in the near future again. Thank you very much, and from all attendees, a big applause.
Thank you very much for the invitation. It's been a great pleasure. So thanks to both of you for organizing it and all the wonderful questions and comments. I really enjoyed it. I have to say this was great. Thank you.
Thank you very much, Maxi. I'm going to switch to Spanish for a quick comment, just to invite all the attendees to come at 6 o'clock sharp for the online dispute resolution section we have today. That's going to be in Spanish, Maxi. Of course, you are invited.
Sorry.
Thank you very much, Maxi. Gracias a todos. Nos vemos hoy a las 6 de la tarde para efectos de tener nuestra presentación con Amada Arley sobre Online Dispute Resolution. Apreciamos mucho su entusiasmo, su participación, las preguntas, y les recomiendo de verdad que vean los materiales y las lecturas que les compartimos. Gracias, nos vemos en la tarde. Thank you very much again, Maxi. I wish I had been your student at Queen Mary. It would have been very, very much.
I should have learned from you.
No. Thank you very much indeed.
Thank you. Bye-bye, everyone.
Gracias a todos. Hasta luego.